Today, the subcommittee meets to examine international internet policies and their impact on U.S. businesses domestically and abroad. I'm glad to convene this hearing with my good friend and colleague, Ranking Member Schatz. The internet, as we know it, has become one of the most important inventions in history. We use it for just about everything. Thanks to infrastructure investments and ingenuity, the internet is now an economic engine driving job creation and unprecedented access to information and opportunities. In a short time, the World Wide Web has transformed into a global, interconnected information superhighway facilitating growth, freedom, and economic prosperity. The multi-stakeholder governing model has been key to the Internet's development across the world. This model has fostered the creation of a dynamic Internet economy that promotes investment and innovation. We owe many of the cutting-edge products and services we enjoy today to the Internet economy. Underpinning this economy is Internet data. As the Internet grows and more people and things become connected, the volume, quality, and variety of Internet data increases. This is driving the development of new businesses and services, and it is enhancing online experiences for consumers. Internet data is an essential commodity for businesses to compete and grow in the global digital market. The importance of Internet data has not gone unnoticed internationally. In fact, it has expanded the focus of the conventional Internet governing agenda. Traditionally, Internet governance has centered on the formation of policies and rules dedicated to the Internet's technical development across jurisdictions. While this remains an important function and primary focus, the increasing value of data has shifted attention to the collection, use, movement, and overall treatment of Internet data. The rise of data localization rules involving how data can be processed in a certain territory of jurisdiction, along with local content requirements, Internet censorship policies, and cybersecurity laws, are a few examples of this growing trend. Policies targeting data and networks often stem from a country's interest in fostering its own innovation or protecting its people from possible data misuse. But here's a new problem. The global nature of the Internet means that the impact and power of these laws goes beyond a jurisdiction's borders. U.S. companies are compelled to change business models or alter operations to achieve compliance in foreign markets. And they're experiencing disruptions in their own domestic operations as well. The result is less job creation, less investment, and less innovation in the United States. Consumers are feeling the effects of international Internet policies also. Overly restrictive limitations on data movement or inconsistencies across jurisdictions ultimately deliver an Internet experience to consumers that is less personalized and more expensive to access. Today, we look forward to examining the impact of global Internet policies on U.S. businesses and consumers, as well as the continued development of the Internet around the world. I would mention that I'm chairman of the Helsinki Commission, and as part of the Commission's mission, we promote economic cooperation overseas. And so I also look forward to discussing the appropriate role that Congress should play in enhancing international coordination on the future Internet policies and empowering U.S. businesses to prosper in today's global Internet marketplace. This is critically important to maintaining U.S. leadership in data-driven innovation and Internet technologies for years to come. I welcome the witnesses here today. I will introduce them in a moment after we've heard an opening statement from Senator Schatz.
Thank you, Mr. Chairman. Thank you for holding this hearing. We're here today to talk about governing an Internet that is truly international. It serves billions of people who have different cultural and economic values and ideas of how it should work, and that presents a challenge. But we also have more specific challenges such as online terrorism, foreign propaganda, interfering in elections, state-sanctioned surveillance, and misinformation that can lead to violence. And as we consider them, we have to ask how they can be addressed without compromising basic human rights, such as free speech or privacy. Approaching any one of these challenges would require a long and technical conversation, and so it's unrealistic to think that we can solve all of these weighty policy issues with a hearing or two. But what we can do here is highlight and demonstrate support for the forums where these discussions can happen in a more comprehensive manner. The IANA transition from NTIA to ICANN is a good example of how the technical governance of the Internet is best served by a process in which all stakeholders participate. These include industry, civil society, academia, users, and governments. Government-driven forums like OECD, G7, G20, and WTO also allow people to come together to address important Internet policy issues, including security, economic development, and trade. But Russia, China, and Iran use these forums to push for agendas that censor speech, enable government surveillance, and restrict free markets. That's why the U.S. and our allies need to maintain our leadership to preserve and advance democratic principles. Similarly, a free and open Internet is in our common interests. The Internet started in the United States. It is intertwined with the fabric of our daily lives, from basic activities like checking the weather to exercising our fundamental civic rights and democratic values. And that's why we have to show up and lead these forums and to continue to be the indispensable nation. This is generally true for international policy issues, but it's especially true for the governance of the global Internet. Unfortunately, our leadership is being jeopardized by this administration. Last year, Secretary Tillerson eliminated the cybersecurity coordinator role and demoted its responsibilities, putting it under the Bureau of Economic Affairs. And earlier this year, National Security Advisor John Bolton eliminated the White House cyber coordinator role. Congress is working to reinstate the Office of Cyber Coordinator at the State Department, and we hope to persuade the White House to reestablish the cyber coordinator role in the NSC. The U.S. government needs to play an active role in helping to set reasonable rules of the road for Internet governance. This means protecting the existing international and multi-stakeholder processes, and in this global context, our standing down will create a vacuum for authoritarian regimes. I look forward to hearing from the witnesses about how we can better engage with the international community to address the many challenges facing the Internet today. Thank you, Mr. Chairman.
Thank you, Senator Schatz. We're delighted today to have the Honorable Michael Chertoff, former Secretary of Homeland Security and co-founder and executive chairman of the Chertoff Group, Washington, D.C., Mr. James Bladel, Vice President of Policy at GoDaddy of Scottsdale, Arizona, Dr. Roslyn Layton, visiting scholar, the American Enterprise Institute in Washington, D.C., Ms. Denise Jung, Vice President for Policy of the Business Roundtable in Washington, and Mr. Christopher Painter, Commissioner, Global Commission on the Stability of Cyberspace, Washington, D.C. Let's take 25 minutes, evenly divided among our witnesses for opening statements, and Secretary Chertoff will begin with you and just go down the table. Welcome.
Well, thank you, Mr. Chairman, and Ranking Member Schatz and members of the committee for holding this hearing, which is very timely. I've submitted a written statement which I request be made part of the record. And I should just point out that I serve with Chris Painter on the Global Commission on Stability in Cyberspace, so we interact quite a bit on this issue. Let me just try to make a few brief points. As both the chairman and the ranking member indicated, obviously the value proposition of the Internet in many respects rests upon its global nature and the fact that it connects up networks all around the world. And therefore, when you have the prospect of fragmentation or localization, you run the risk of undermining the fundamental value of the Internet because you would wind up with a number of different networks. This is important not only because we value freedom and the ability to communicate with others around the world and to have discourse about matters of public importance, but because this is critical to our economy. The reality is the internet has transformed the nature of our economic activity. It allows us to promote exports. It allows us to, if I can use the phrase, disintermediate between buyers and sellers. So we now have the ability of people to sell directly, whether it's auctioning on eBay or signing up to look for drivers under Uber or Lyft or other ride-sharing programs. And in many respects, this is part of what is fueling global growth around the world. It's also true that much of the innovation and the ingenuity behind the internet, which is part of the market value of many of our most prominent companies, depends upon having a global market. And that means a global internet. Without a global internet, that market dries up. So we have a very strong interest in dealing with this issue. It also means that no one country can control the outcome. We have to work with our partners. Now, candor compels that we recognize that the Russians and the Chinese have a different view. And in many cases, to the Russians and the Chinese, information they don't want their public to read is what they regard as cybersecurity. And that's, of course, the opposite of what we view as important. So I would make, I think, 3 points about what we ought to address. One is, I do think we need to continue to promote what has been described as the multi-stakeholder model of internet governance. That means making sure we get not just government, but civil society, business, and consumers into the mix in deciding how the internet is going to be operated. The Russians and the Chinese often look to put the governance in bodies like the UN, which would politicize and give them, in many cases, control over the outcomes for their own purposes. And I would emphasize that often rules that appear to be merely technical actually have a great deal of real substance, because your ability, for example, to control the domain name registry system and to decide, who controls basically the traffic flow, in many cases is the key to whether you censor the internet or you have it be wide open. A second issue is we do have conflicting laws in different jurisdictions. The internet is borderless, the data is borderless, but the laws have borders. And we often do wind up with conflicts. Congress has passed the Cloud Act, which has opened the door to our resolving some of the conflicts about lawful access by the authorities to data that may be held in another country, and that's a good step forward. And we need to continue to work on resolving these disputes among legal jurisdictions about who gets to access information and what the substantive rules are. In particular, because we prize the First Amendment, we want to make sure that other countries don't use their power over multinational global internet companies to drive a vision of censorship that would fundamentally undermine our constitutional values. And finally, I would say, and full disclosure is in a book I've just written recently, that we need to talk about what privacy is like in an era when we are generating so much data globally that the idea of keeping it all hidden is a ship that has sailed. And now it becomes an issue of how do we control the data and what rights do we as citizens and consumers have to make sure that our data is not being used in ways that we don't agree to or that will hurt us. And so these are very meaty topics, and I look forward to answering questions from the committee on any and all of these. Thank you very much.
Thank you, Mr. Secretary. Mr. Bladel.
Thank you. Good morning, Chairman Wicker, Ranking Member Schatz, and subcommittee members. My name is James Bladel, and I'm the Vice President of Global Policy for GoDaddy, and we appreciate the opportunity to testify before you today. GoDaddy is the world's largest web platform dedicated to independent ventures. We provide the tools, insights, and people necessary to enable small businesses and aspiring entrepreneurs, or anyone with an idea, to get that idea up and running online. And every idea starts with a domain name. A domain name, whether it's a .com, a .org, or a new extension like .app or .blog, is essential to creating an online identity. GoDaddy currently manages over 76 million domain names for our 18 million customers worldwide. And whether that customer is a florist in Mississippi, or a baker in London, or a web designer in Mumbai, Our mission is to provide an excellent customer experience that is uniform around the world. The focus of this hearing is on the impact of international policies and regulations on end-user experiences and global competition online. And today I would like to discuss the following three issues. First, the adoption of laws and regulations by countries that are designed to exclude American companies. Second, the patchwork of privacy laws and regulations. And third, the .com cooperative agreement between NTIA and VeriSign, which underpins the global internet domain system. Internationally, we're seeing an increasing number of countries adopt laws and regulations that make it more difficult to serve our customers in those markets. We have encountered numerous examples of foreign regulations on internet providers that would require us to establish a local presence or use local banks or even hire a local workforce, all in order to gain access to that market. Some nations aggressively regulate content and censor political or religious views. Taken together, all of these regulations stand in the way of GoDaddy reaching new customers, competing in new markets, and developing innovative products. And laws like these are harmful to providers and to consumers alike and are a barrier to free trade. There's also an increasing number of new privacy regulations, such as the European Union's new General Data Protection Regulation, GDPR. And these regulations have created a patchwork of laws with which companies must comply in order to operate globally. GDPR compliance was a major undertaking for GoDaddy. GDPR has touched every aspect of our industry, but most notably, it has significantly disrupted the Whois service, which is a directory of contact information for domain name registrants. Now, Whois is a two-edged sword. It serves an important tool for law enforcement and other stakeholders, but it's also a goldmine of personal data for spammers. Currently, we're engaged with representatives of law enforcement agencies and our colleagues at ICANN to try and strike the right balance between providing access to Whois for legitimate purposes while also protecting the private information of our customers. Also crucial to the health of the internet is the 20-year-old cooperative agreement between NTIA and VeriSign that governs the .com registry. As you're aware, .com makes up about 80% of domain names, and the cooperative agreement holds the wholesale price of .com domain names at $7.85 per year. This is scheduled to expire in November, and it's our understanding that NTIA and VeriSign are currently in talks to renew and possibly amend this agreement, which could potentially raise prices. GoDaddy serves millions of small customers, and in our experience, they're very sensitive to any price increase. We believe it's important to preserve price caps in any renewal of the cooperative agreement. Eventually, we believe our industry and all consumers would benefit from the full .com agreement being put out for competitive bid. The internet has matured over the last 20 years, and while we have no complaints about VeriSign's performance of the contract, there are now several companies that could capably operate the .com registry equally as well and perhaps at lower wholesale costs. So thank you again for the opportunity to testify here today. We believe the United States must continue to push back on protectionist policies imposed by other countries and to help mitigate a global patchwork of inconsistent and unclear privacy laws. And further, we are hopeful that NTIA will increase transparency and extend the current .com pricing as associated with any renewal of the cooperative agreement, and engage with ICANN and other stakeholders to put that agreement out for competitive bid. So thank you for your time, and I look forward to your questions.
Thank you very much. Dr. Layton.
Thank you, Chairman Wicker and Ranking Member Schatz. Chairman Wicker, thank you also for your leadership of the Helsinki Commission on Security and Cooperation and your defense of human rights. It reminds me how Americans from every part of our nation can play a role in internet policy. For example, Mississippi is innovating in telemedicine and precision agriculture. As we enter the 5G era, our economy will broaden with smart application for cities, cars, and so on. It's not just search engines and social networks. We want to export these new 5G platforms and services, and this underscores the importance of today's hearing. Now, our country has practiced international technology policy for at least 230 years. Alexander Hamilton's report on the subject of manufacturers from 1791 advocated for modernizing the American economy to break dependence on slavery and supersede England in manufacturing. We revere Hamilton for his enlightened contribution on the importance of central government. Equally, we revere Thomas Jefferson for his championing of individual freedoms. Our policy legacy is thus to hold the balance of the rule of law with individual rights, and these values should underpin our approach to internet governance. The United States is 1/3 of the global tech economy, and we should shape the international environment with our values. But we won't have any credibility if our policy is just about American companies making money. We must export a value system that legitimately empowers and rewards other nations to participate in a free market economy, to respect the rule of law and individual rights, to limit regulatory distortion, to protect property, and to improve quality of life. This is how we ensure that our regime is the most fair, rational, and humane. Now, a popular misconception is that the Global Data Protection Regulation, or GDPR, protects privacy. It does not. The GDPR is about data regulation, specifically 173 rules on data regulation. Now, Europe is the destination of 2/3 of America's digital goods and services, and U.S. companies are now suffering because of its cost and complexity. Now, I live in Copenhagen, so I can experience this. I can no longer look at the newspapers such as the LA Times, the Chicago Tribune, the New York Daily News, the Hartford Courant, Orlando Sentinel, and Baltimore Sun. Additionally, 60 additional newspapers in Illinois, Indiana, Minnesota, Missouri, Montana, Nebraska, Nevada, Washington, and Wisconsin are not available. This reduction in content has reduced visibility for U.S. advertisers and has shut them out of independent ad exchanges. Retailers Williams and Sonoma and Pottery Barn no longer sell in the EU. Game companies from Washington State have shut down their online communities. A Nevada provider of online IT services no longer takes European customers. A mobile marketing platform company with 6 offices in the United States has closed its EU operation, and even the website of the Association of National Advertisers is not available. Now, if we adopted such a measure in the United States, it would likely violate our freedom of speech, as the government requirements are so onerous that they reduce expression. Indeed, California's GDPR-inspired legislation should be preempted federally for this very reason. And the EU Parliament is using the GDPR as a pretext to torpedo our faithfully negotiated Privacy Shield agreement. These actions violate international law, and we need to challenge them in court. Now, the GDPR is a global standards war. The EU tried this before with the 3G GSM mobile standard, hoping that we would get on their platform. We didn't copy them, but we leapfrogged to 4G LTE. Now we need the same strategy with the GDPR. Not to copy, but to make a better and different alternative for data protection. And we can do that by meaningfully empowering consumers through digital competence education and incentivizing privacy-enhancing technologies. I want to applaud Senator Klobuchar for her leadership on a proposed bill. In closing, we must walk the talk. For a rational, predictable, and consistent framework abroad, we need to start at home. Therefore, the right policy should be a consistent framework with same rules for all players, grounded in modern evidence-based standards of antitrust delivered by the Federal Trade Commission. This also requires addressing the regulatory prejudice that has deterred flexible pricing and innovation in business models and platforms. For example, the cooperative agreement between VeriSign and U.S. Department of Commerce oddly caps the wholesale price of .com domains, but allows arbitrage in the secondary market. Now, just as Jefferson has secured the Mediterranean sea lanes for free trade in the 19th century, we have to secure the information lanes for the free flow of data today. And this is now our leadership challenge.
Thank you very much, Dr. Layton. Ms. Jung.
Chairman Wicker, Ranking Member Schatz, members of the subcommittee, thank you for the opportunity to testify on behalf of the Business Roundtable. Today, few companies can compete and succeed without making extensive use of data and digital systems. But recently, there's been a rapid increase in the number of policies around the world that undermines digital innovation, trade by creating fragmentation, uncertainty, significant compliance costs, and other unintended consequences. The compliance environment is increasingly cumbersome for large companies and simply impossible for small companies and startups to comply. The EU and China are the most active players in rolling out digital regulations, but India, Russia, South Korea, and other Asian and Latin American countries are ramping up efforts to develop and enforce a wide range of cybersecurity, privacy, and data localization policies. China has the most aggressive regime in place, mandating all important information and personal information be stored locally in China. As currently defined, the law would require any entity that owns or operates a computer network and applies to a vast assortment of different types of data. India, Russia, Nigeria, South Korea all have enacted laws that prohibit transferring various types of business and consumer data. In fact, at least 34 different countries have data localization requirements that can raise the cost of hosting data by an estimated 30 to 60% for covered companies. Approximately 120 countries currently have data privacy laws, and many more countries are considering legislation in this area. Some companies have decided to discontinue offering products and services in the EU because of GDPR compliance costs, which are so high that they can no longer justify being in the market. For example, some firms are blocking EU-based users from their products and services, including from visiting their websites, to avoid facing steep fines of 20 million euros or 4% of annual revenue, whichever is higher. The GDPR alone is costing global Fortune 500 companies a combined total of $7.8 billion this year to comply. Fragmentation of domestic policy regulations in the United States is also on the rise. In addition to several existing sector-specific federal and state privacy regulations, California recently passed a privacy bill that applies broadly across many sectors. Numerous other privacy proposals are pending in state legislatures that, if passed, would further increase the complexity of privacy regulations across the U.S. Cybersecurity regulations are also expanding globally. The financial services industry is an example of a sector that faces an expanding number of international cybersecurity requirements, with more than 40 different policies, including overlapping mandatory risk assessments, penetration testing, and incident reporting to multiple authorities in each country. Now, don't get me wrong, cybersecurity is a serious matter. We should have mechanisms in place to ensure adequate protection, but uncoordinated policies across countries means that companies must reconcile competing regulations that divert resources away from security toward compliance. A fragmented international digital policy landscape will likely have the most significant impact on startups and small and medium-sized companies with limited resources to comply with ambiguous requirements and opaque reviews in countries like China, or excessive paperwork associated with EU policies. And emerging technologies like artificial intelligence and blockchain are also hindered by regulatory uncertainty. For example, the data minimization, automated decision-making, and right to erasure provisions of the GDPR could create barriers to the commercial development of these important technologies. In light of these trends, I would like to end by outlining 4 areas for congressional focus. The first is to work on establishing alliances, particularly with like-minded countries, to counter technology restrictions as a condition to accessing foreign markets. We are more effective with strong partners and allies. Second, the U.S. must lead in the development of international norms, best practices, and standards for cybersecurity, privacy, and cross-border data flows, as well as emerging technologies such as AI and blockchain, because rules for those technologies do not yet exist. Third, the U.S. must work to align and harmonize policies to avoid global fragmentation. We cannot afford to be missing from the important international forums on digital policy issues, as China and other countries are actively seeking to rewrite the rules of the internet that are fundamentally at odds with open markets and democratic values. And finally, and perhaps most immediately, Congress should act to protect transatlantic cross-border data flows under the Privacy Shield by making the ombudsperson a permanent position within the State Department. It should also act swiftly to confirm the nominees for the Privacy and Civil Liberties Oversight Board, which plays a critical role in fulfilling the requirements under the Privacy Shield. Mr. Chairman, thank you for your leadership in holding this hearing and for encouraging a dialogue. I look forward to taking questions.
Thank you very, very much. Mr. Painter.
Chairman Wicker, Ranking Member Schatz, members of the subcommittee, it is a pleasure to be here today to discuss the impact of global internet governance on American businesses, end users, and the U.S. policy of promoting and maintaining an open, interoperable, and secure internet. For over 26 years, I have devoted my life to cyber and internet issues, including most recently serving as the first coordinator for cyber issues at the Department of State. In that role, I work with components across the department, the interagency, and outside stakeholders to advance the U.S. vision of cyberspace and combat both technical and policy challenges. I'll focus today on some of the policy challenges and recommendations to address them. First, it's important to note that the policy threats we face, though distinct, are often interrelated and have economic, human rights, and security elements. For example, when China claims absolute sovereignty over its cyberspace and erects a digital wall around its territory in the name of security, that has profound economic and human rights implications. It is vital, therefore, that our response to these challenges not be siloed but be coordinated. bringing together the full range of departments, agencies, and other stakeholders to advance an integrated and strategic U.S. policy. Second, cyber and internet issues are now being debated in virtually every country and every international and regional organization. Indeed, I believe we've reached an inflection point where the issues discussed and the decisions reached in these multiple forums will have a major impact on the future of the internet and cyberspace. Accordingly, advancing the U.S. vision of cyberspace, including U.S. commercial interests, requires unprecedented U.S. international engagement and strategic U.S. leadership. Among the many policy challenges we face are threats by repressive regimes to replace the system of multi-stakeholder internet governance with one that is driven by government-only multilateral bodies, in part to control content and curtail the free flow of information, threats posed by China, Russia, and others to online freedom that have both negative human rights and economic impacts, mandatory data localization requirements that are not scalable or economically practical and are often used by repressive governments to help monitor and control their citizens, and countries and multilateral bodies around the world enacting or considering regulatory policy or legal regimes dealing with some aspect of cyberspace, including online privacy, cybersecurity, market access, and emerging technology, that conflict with U.S. values and interests or risk creating conflicting regimes that fragment the internet. And finally, threats by nation-states, organized criminal groups, and other bad actors that threaten to undermine our confidence in the internet and network technologies and strike at the very core of our economy and democracy. My overarching recommendation to address these challenges is for the U.S. to step up its international engagement on these issues and make them a true national priority. This requires an enhanced structure, resources, and a whole-of-government cross-cutting strategy. On structure, I applaud the continued efforts of my former colleagues in State, Commerce, and other agencies, but I believe those efforts have been hampered by the lack of a sufficiently high-level office at the State Department and the recent abolition of the cyber coordinator position in the White House. I commend the House and Senate efforts to restore, strengthen, and institutionalize my former office in the Cyber Diplomacy Act, and I'm particularly pleased that these efforts were bipartisan, reflecting the bipartisan nature of most of these issues. In the past, necessary whole-of-government coordination on these cross-cutting issues has been significantly boosted by the cyber coordinator position at the National Security Council. The loss of that high-level position, coupled with at least the temporary demotion of my prior office, complicates interagency coordination and also sends an unfortunate signal to both our friends and our adversaries that the administration does not really prioritize these issues. Resources are also vital. This importantly includes funding for capacity building that was severely cut last year. Capacity building includes working with foreign governments on aspects of internet governance or regulatory policy, helping countries enact appropriate laws and strategies, and working with countries to boost their ability to combat cybercrime and have strong cybersecurity capabilities. For a relatively small amount of money, targeted capacity building not only helps the U.S. by helping other countries gain the ability to work with us, but it also helps win the support of developing countries for our vision of the internet and cyberspace. It's also important the private sector, civil society, and other stakeholders to continue to engage in these efforts and enhance their participation. Though many companies and civil society groups already make invaluable contributions in a variety of international forums, given what is at stake, we must find ways to help increase participation. Finally, it is important that the U.S. has a high-level, cross-cutting, integrated strategy that leverages all relevant government agencies, outside stakeholders in like-minded countries to deal with the many challenges we face internationally and help to direct and prioritize our engagement. I make a number of other suggestions in my written testimony, including strengthening multi-stakeholder institutions, including the Internet Governance Forum, showing leadership on privacy and other Internet policies, addressing data localization through, among other things, the Cloud Act, and supporting cybersecurity, cybercrime, and stability efforts, but all are dependent on an effective and strategic international engagement plan. I look forward to your questions.
Well, thank you all for this very, very fine testimony. It sounds like we've got some challenges. And in that regard, Secretary Chertoff, the NTIA recently issued a notice of inquiry soliciting public comment on its international internet policy priorities. In your testimony, you mentioned how so much of the internet's value is in its global nature. So how do we balance the business needs for the free flow of data with the point you make about the need to protect our freedom of action, which requires that we take greater ownership and control of our data, even when it is accessible to others?
So, Mr. Chairman, I think
I think so.
now it is, yeah. So I think, Mr. Chairman, you're referring to something in my book there. Here's
And page 4 of your testimony.
right. So here's what I think in terms of.
By the way, how's your book doing? Here it is.
There it is. Yeah, I think it's doing well. You're reading it.
Hundreds
That's
of
great.
people are watching right now.
I do think that people do need to take ownership of their data, and they do need to have more control of their data, particularly because so much is being generated now that really if we don't have some mechanism to assure that we have a say in what is done with it, we really risk our freedom. At the same time, I'm nervous, as based on the testimony we've heard up to now, that the European method tends to be a little bit overly bureaucratic and overly heavy-handed in terms of regulation. To me, the solution is to recognize that certainly with most of the world that shares Western values, we have a common general approach and belief in the importance of individual freedom and individual privacy. And we should acknowledge that and work in a cooperative way to develop a system of rules that honors that fundamental objective, but doesn't get so particularistic and so heavy-handed that it actually creates barriers to the free flow of information. We've succeeded in doing this in other areas, particularly with the Europeans. And to echo what my co-witnesses have said, this does require consistent engagement by the U.S. government and by U.S. civil society with counterparts in other parts of the world.
Dr. Layton, you specifically testified, quote, a popular misconception about the EU's General Data Protection Regulation is that it protects privacy. It does not. Talk about that, and if we're going to try to negotiate with the EU on tariffs and preferences, shouldn't the GDPR be part of our negotiation?
The short answer, yes, absolutely. Just so you know, the word privacy only appears about 3 times in the entirety of the GDPR, and it's specifically their version of data protection. And I think it's our concept, for example, you can go to many countries in Europe where people's mobile phone numbers are publicly available, their tax returns are publicly available, people swim naked in public places. So we have very different conceptions of privacy. What I would like to underscore is that the GDPR is actually a geopolitical, not a humanitarian move. It is coming after 10 years of economic malaise in the European Union. There is deep dissatisfaction with Brussels. Less than 40% of Europeans vote in the election. So this is a reaction to that. And I would say the Europeans that I know, they want prosperity. They want to move forward. The public opinion was not on board with the heavy-handed approach that the EU took. And
I believe you say that it is not evidence-based.
That is correct. The idea of an evidence-based process would include a process, a data, and outcome. So in the 173 provisions, you've had something over a decade of GDPR kinds of rules that have been in place. And after a decade, what we can see is that only 20% of Europeans even shop outside their own country, and only 20% of businesses are online. So the rules have not worked to increase trust in their own online system. And that was the whole idea, that they would have a digital single market the way we do in the United States. And these rules have not helped them to achieve those goals.
So your position is not good for Europeans.
No.
It's not good for Americans either.
Absolutely. And just to share one last thing that's just happened, now the European soccer leagues, they have now adopted a policy that they will not trade the soccer players, and they cannot disclose the information on their injuries. So if you want to buy a particular soccer player, trade them to your team, you're not allowed to know what injuries they have. So this is also hurtling back on them. Governments as well. The European governments are also liable, and there's abuse.
Very good. We'll probably take another round if we can. Senator Schatz.
Thank you, Mr. Chairman. Thanks to all the testifiers. I'll start with Mr. Painter. You were the State Department's cyber coordinator for 6 years, and you described the importance of the position kind of as a policy and, in a way, in the abstract. I'm wondering if you can give me some specific examples of what you did that made a difference in terms of the governance of the Internet.
Sure. Among other things, and I think really central to all of this is showing U.S. leadership and building alliances with other like-minded countries so that we could push back on a lot of the things we talked about today, particularly attempts by Russia, China, other countries to take over the internet or to impose internet or multilateral control over it in venues like the ITU, the UN, and other places. Getting that coalition of countries and having that constant interaction with them was key to doing that, and that was the U.S. taking the lead. We weren't sitting on the back bench, and I think that was very important. Also, incorporating issues around internet governance, economic issues, human rights issues in every dialogue we had with every country. We had all these whole-of-government dialogues with a number of other countries, and that raised these issues, so they weren't stovepiped in one area or another. We also helped launch the Freedom Online Coalition, which is a group of about 30 countries to promote freedom online, and also working in all these different international venues. And we created and advanced a framework for cyber stability that included the application of international law, norms of behavior in cyberspace, confidence-building measures, which again addresses some of the instability issues of the internet, because the internet as a platform needs to be secured to really underlie all the commerce that we're hoping that happens there. And a number of other things too.
So we should reestablish the position, enshrine it in statute. What else should we be doing?
So I think there's a number of other things that we can be doing to promote this. I mean, one is, to step up this whole of government level engagement across the board and work with companies, and that involves forming coalitions again with like-minded countries who would support us, who have the same basic view, and engaging in that level. And another thing is to provide concrete alternatives. We don't like some of the things that are going on out there. I think we all agree on that. But if the U.S. isn't providing concrete alternatives when some of these countries or collections are trying to export their laws, for instance, China, or even the EU with GDPR, if we don't have a key or an alternative that is an attractive alternative to other countries who are looking at this, they're going to adopt those standards, and there's not going to inure to our benefit. So having things like there was in the Obama administration, the Privacy Bill of Rights, there was some legislation to try to bring that forward. If we had a concrete alternative that really balanced all the issues that the panelists talked about, but provided an alternative to others, I think that helps. And I think those are really some of the key things we could do. There are many others, but those are two of the important ones.
Thank you. Secretary Chertoff, I think a lot of us struggle with the desire to look at what happened in 2016 in terms of election interference, especially on social media platforms, and to want our national security agencies and the platforms themselves and even voters to be more engaged so that we're not as vulnerable in the future. What we don't talk about as often is that we have to be pretty planful and careful and precise in terms of what model we establish for working with the government to push back against constitutionally protected speech. And that's the difficulty, because those tools that we establish will be an example not just for our allies and our like-minded friends around the world, but some of our adversaries and authoritarian regimes. And I'm wondering if in the minute or so remaining, you can talk about how we strike that balance, and I'm not sure you can answer that in a minute. So where we work on striking that balance, to me, is the fundamental question.
Well, Senator, I think that's exactly the right question. Briefly, I would say this. I do think we have to be very protective of the First Amendment, and therefore be extremely cautious about proposals to regulate content or say certain content is off limits. The First Amendment basically gives us freedom of speech, except in a very narrow category of things. Where I do think there's more room for actually taking some affirmative action is in the area of disclosure of identity about who is actually posting things. So, for example, I know there's legislation pending about requiring foreign entities that buy ads or otherwise pay for space on social media platforms. I think that's consistent with what we do offline, and there's no reason not to do that. Likewise, I don't think there's any First Amendment protection for impersonating Americans or for botnets or for automated trolling or other ways of manipulating search engines. And those are areas I think we could quite usefully focus on working together with the social media companies.
Thank you.
Thank you, Senator Schatz. Senator Fisher.
Thank you, Mr. Chairman. Dr. Layton, You had mentioned that in Europe there's some different expectations when it comes to privacy. I'd be interested to know how you define privacy in the digital era, and how do we manage the privacy expectations of consumers?
Well, I'm going to give you the research that the European, the Agency for Network Security actually developed, and said that privacy and trust is a function of four things. It's the level of education of the consumer or the user. It is the level and types of technology. It's the business practices and the institutions. And when you look at something like GDPR, it only focuses on two of the four things. So what I would say, if we only did one thing, we, as a nation, individuals, we have to do more to have people be digitally competent and digitally aware. And it's maybe not necessarily something that the Congress defines exactly what it is, but we have a tremendous amount of information and ability to communicate. So, for example, I want to recommend Mr. Chertoff's book, which I just read, and he talked about the first thing, buyer beware. The number one thing in cybersecurity, you have to take responsibility for the platforms, the networks that you use.
So to define privacy in the era that we are in now, this digital era,
Right. So
the first thing would be buyer beware.
But taking responsibility,
it's up to each of us to figure
well,
out.
there's a gap
those
right
are.
now. There's a gap in what, we need to close the gap in terms of the idea of a digital literacy, or what are the 10 things I need to know before I go online to protect myself. And so that is the gap which is missing in the GDPR today. It's what the scientific research shows that's important. And we don't even need to make legislation to do that. We can actually, each and every person can take a step up to take responsibility for what we do online.
So the expectation is that each individual is responsible, and the internet is a space where you take your chances.
No, that's not what I'm saying. I'm saying the part of the four factors that I mentioned, we're missing 2 out of the 4 right now. Okay, so we have lots of regulations, we have lots of rules on businesses, okay, we have lots of institutions, we're missing education, and we're missing incentives for privacy-enhancing technologies. So I'm trying to promote that as individuals, we take more responsibility for what we do.
Okay, Mr. Secretary, do you feel that a lack of any kind of unified data privacy policy could lead the United States to becoming more isolated?
I do, Senator. I do, Senator. I think that, first of all, even within the country, California's now passed a law that deals with the issue of control of data. We could wind up with multi-state laws that are conflicting with each other, at least inconsistent, and certainly would be helpful at least to smooth it out here. But beyond that, to come back to the fundamental point, I recognize that a country like Russia or a country like China is going to be fundamentally different in their attitude to issues like controlling data and controlling information. And so, therefore, there may be limited scope for agreement there. But I do think with Western countries, although their particular approach tends to be different than ours, tends to be much more regulatory, micromanaging, I think the basic value system is very compatible. And that's where I think an ability to reach an agreement as to what our overall objective is would open the door to then working on some of the differences which have created barriers for our businesses, as well as some confusion about what the rules are. So to me, this is about ultimately how do we protect people's rights to make sure their data isn't being used in a way that's contrary to their interests or that invades an area that we think they ought to be in control of.
Many of us on this committee also serve on Armed Services Committee, and we worry about the security of the information that agencies have and that agencies also share. A lot of times, civilian agencies don't have the security, say, as the Department of Defense would have. How can we ensure that that information that's out there is more secure? In your role as head of the Secretary of DHS, you were very involved in that. What do we as policymakers need to look for?
I think the challenge here is unity of effort among a lot of different agencies, many of whom don't regard security as a core mission. And unfortunately, Exhibit A is the Office of Personnel Management, which probably everybody in this room was a little bit of a victim of that hack. I do think the administration has made the right decision in designating, in terms of government security, DHS as playing a lead role. And I think it's important to make sure that the department has the authorities necessary to make sure that all the agencies live up to the requirements of basic cyber hygiene and cybersecurity, including continuous diagnosis and monitoring, response plans, and other kinds of elements of a layered defense. So that set of authorities, making sure that's firmly lodged in one accountable agency and that it's appropriately funded, I think would be a big step.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Fisher. Senator Inhofe.
Thank you, Mr. Chairman. I'm glad that Senator Fisher brought up the situation on the defense authorization bill, because I see a lot of similarities here. In fact, we will be voting on that. It passed the conference passed the House last week, and we'll probably have it on Thursday, my guess is. But I've been watching, and this does change with administrations. We went through an administration, 8 years, the Obama administration, that, you know, in all fairness, really didn't have the priority on national defense that that a lot of us believe it should have. As a result, we have some areas, I'm getting at, trying to determine where Russia and China are now relative to us in the subject at hand in this committee. Because I can tell you right now, there are a lot of areas in defense, one being in the areas of artillery. Artillery is measured by rapid fire and range, and actually Russia and China are ahead of us in both areas. They're ahead of us in our nuclear activities, our triad, and this hypersonic. Hypersonic is the big thing that's coming into the defense system, because it's a system that operates at 5 times the speed of sound. So it's very significant. Now, so I'd like to start off by maybe I could ask anyone, Mr. Bladel. I keep hearing, and you folks are experts, but I hear that yes, we're still in our areas a little bit ahead of China and Russia, but they're catching up. Is that an accurate characterization?
Senator, thank you for the question. I think I probably shouldn't speak to their capabilities as state actors. I can say from our perspective, as a private sector company, we see that the largest and most frequent attacks, cyber attacks on our systems, are originating from Russia and from China, and our cooperation is primarily through private sector and industry coalitions and coordination both vertically and horizontally throughout the technology industry.
Yeah, and you mentioned also, it wasn't in your written statement, but when you were speaking a moment ago, that there are now 120 countries that have a data processing laws. So it means there are a lot of them that don't have those. And we should have, adequate protection. I think everyone agrees with that. And we're more effective with partners. Now, the question I would ask you is, we all agree that that's right, but how do we cement these relationships with the partners that should be doing the job with us? What's the most effective thing we can do to go out and attract partners who would also agree that we're more effective if we do it as a group?
So, Senator, I think that point was made by one of the other panelists, but I'll go ahead and build on that, that the proliferation of different privacy regulations is creating confusion, it's creating friction, and it is a growing issue, as another one of the witnesses' testimony noticed that GDPR is gaining momentum, or GDPR equivalent type frameworks are gaining momentum outside of Europe. And I think the answer is that we continue to show U.S. leadership by helping to push back on the differences and the inconsistencies between the various frameworks, and focus on those areas of commonality and try to rally around those core principles of what we believe to be the protection of data, but allowing the free flow of information and the conduct of commerce across borders.
That's good. Secretary Chertoff, you had made the statement that specifically talking about the role of the United Nations and that Russia and China want to enhance that role. I think we all understand and agree with that, but what's the most, how effectively could we try to accomplish that?
Well, I think that the U.S. has been generally consistent. I'm in trouble with this. I think the U.S. has generally been consistent in saying we don't believe the UN is the right forum for dealing with these issues, partly because, particularly with the veto in the Security Council, that would essentially politicize the process of dealing even with the technical aspects of the Internet, which is why, of course, the Russians and the Chinese want to do that. I think we need to continue to look to, again, this multi-stakeholder model where we go to fora where we can engage the private sector, the business community, and consumers in coming up with proposals for how to reconcile the various interests that are part of the Internet. And just to follow up a little bit on the prior question, a lot of, they used to say a lot of life is just showing up. A lot of dealing with these issues is showing up. By being present, by dealing with your counterparts in other countries, my experience is you often find there's a greater degree of fundamental agreement than might be evident at first. But in order to be able to have the impact, you've got to play.
Yeah. All right. Very good. Thank you very much. Thank you, Mr.
Thank you, Senator Inhofe. Senator Capito.
Thank you, Mr. Chairman. Thank all of you for being here today. I would like to say just at the onset that the Department of Homeland Security is in New York today announcing I think a really great move on their part, which is a new cyber hub to protect our critical U.S. infrastructure. Sort of goes a little bit into what we're saying, or a lot of it into what we're saying today. But to be that flexus point or nexus point of the nation's banks, energy companies, and other industries to help protect them from major cyber attacks. So I want to say thank you to the Secretary, and I know that she probably asked for your advice as she was moving forward. So I think it's a very good thing. On the, all of you have talked about the GDPR and the regulations that have come from the EU. Some of you have addressed it in a problematic way. I think Mr. Bladel, you talked about how it's causing you to divert assets into figuring out how to do this. I think Dr. Layton, you said interestingly in yours that a popular misconception is that it protects privacy. You said it does not. It is about data protection, or more accurately, data governance. And your last statement in your written statement says, data protection is a technical issue, whereas data privacy is a legal issue. So do you think as we look at governance, we need to look at both of these issues together? If you could talk about that a little bit.
Surely. I think the key difference is when privacy we might see in the United States as a natural right and something inviolable, something we're born with, versus in the European conception, it's a government-granted right. So the key difference there is, what government gives, government can take away. A key difference from the U.S. perspective is that our natural rights are things that are inherent. We don't ask anything of anyone else to have those rights. Versus a European approach is it's making requests and requirements of others in order to do those things. So our understanding of privacy is fundamentally different. The other aspect is amongst this 173 provisions, it's really a hodgepodge of essentially a laundry list of a set of stakeholders that want to have certain regulations to be able to go after American companies, to achieve outcomes that they could not achieve in the courts or through antitrust. And the GDPR itself actually reverse engineers a number to create a class action lawsuit culture so that people can have standing in courts to be able to bring lawsuits they couldn't before. To date, the Europeans didn't want to have this sort of U.S.-style class action lawsuit culture, for better or worse, and that's changed now, so that we have now the abuse of complaints. You can get 1 million complaints in a day that is just automatically generated. So there's 62 data protection authorities in the EU, and they don't have training on how to do this. The enforcement will be very disjointed. It's primarily focused on U.S.
So I guess if we're looking at this in terms of the future, we need to look at lessons learned here as they've been trying to implement theirs. So, Mr. Painter, in your statement, along those same lines, you say that the GDPR enshrines the right to be forgotten, that mandates that EU individuals can force service providers to remove certain information about themselves. When I asked Mark Zuckerberg, when he was in front of our committee, I asked him, do individuals have the right to delete their individual information? In other words, remove themselves from Facebook. Personally, I believe they should have that right. He assured me that they do have that right and that it does happen, but I'm still not convinced it's not out there somewhere and that cannot be retrievable in some form or fashion. So I don't know if you have a statement on that.
Yeah, so I think there are positive aspects of deleting your data, and I do agree. You should be able to delete your data and control your data and have access to your data and have transparency into your data. That's some of the data privacy things we should be looking at. What this does, though, I think, is create a tension with the First Amendment and human rights, because what it says is you can delete your data anywhere. You could do it perhaps as a public figure or others, newsworthy stories that people have a right to consume. It impacts First Amendment rights. So the trick is making sure you're doing this in the right way. And the approach taken in the EU, I think, is too broad. I totally agree with you, though, for providers like Facebook and other providers like that. It's your data, and you should have a chance to edit it, to remove it, et cetera, and have access to it.
Well, it seems to me just in the general sense, if we're going to figure out how to move forward internationally on privacy, there's so many conflicts, and then we haven't even, in my questioning, gotten into what Russia and China think your right to privacy is, which is obviously vastly different. So thank you all very much.
But before I recognize Senator Peters, was the GDPR a statute enacted by the European Parliament, or was it written by a regulatory agency? I know it just went into effect in May. Who can answer that? Dr. Layton.
Sure. So if you'll ask Jean-Philippe Albrecht, who's the member of parliament, he's called the father of GDPR, he said that it essentially formalized existing laws in the European Union.
Well, of course, that's not.
That there would be parliamentary laws, and then there would be an EU.
Who issued it?
The parliament. It's not that, so that's their Congress, if you will. The EU Congress.
But I mean, I think it's important. As I understand the EU regulation making or law making, it's the Parliament, it's the Council, which is all the member states, and it's the Commission, which is essentially the bureaucracy, and they come together. And in fact, they're looking at something around certification for cybersecurity products right now, which the U.S. has been engaging in. So this is a perhaps cumbersome process, but there's chances for the U.S. to intervene, to have input, and we need to make sure that's happening.
Would it take an act of the Parliament to amend or change the GDPR? Okay. Senator Peters, thank you for allowing me to interject there.
Thank you, Mr. Chairman. Thank you for holding the meeting and the ranking member. Thank you, and to our panelists. Appreciate the discussion. You know, as we talk about the GDPR going into effect, we have to remember that the United States, if we're going to show some leadership, we probably should have some comprehensive policy regime ourselves, which we are still lacking in this country. It's hard to show leadership to the rest of the world if we can't even get our act together here in this country. And as all of you know, our largest tech companies are under some pretty intense global scrutiny right now for their mistreatment of data. And while other countries are beginning to levy fines against these companies, we are just now beginning to ask the questions of whether or not they're too big and perhaps in need of being reeled in somewhat. So amidst some of these antitrust discussions, Mark Zuckerberg and other tech giants are now recognizing that perhaps some privacy regulation may be necessary. However, there still seems to be a lack of will to participate in productive discussions about what these regulations should basically look like. So my question to the panel is, as we talk about GDPR as it relates to global e-commerce and the impact that it's going to have on U.S. companies, from your perspective, were companies that were affected by this regulation, were they at the table? Were they part of the discussion as it went forward? Or was their lack of participation resulting in why we're in the position that we're in today and the concerns that you've raised? I mean, we start down here. Mr. Chertoff.
Well, I was not involved in these discussions, but my understanding and impression is a lot of these companies do have a significant presence in Brussels and did attempt to lobby and interact. But I think the effect of that is diminished if the U.S. government's not fully engaged for obvious reasons.
Mr. Bladel.
Yes, Senator, our company was not engaged in the development of GDPR. However, we were engaged as part of the multi-stakeholder governance forum, particularly in ICANN, in understanding what to do with GDPR and particularly how it impacted our industry.
Did you see it coming?
We probably had less notice than we would have liked, Mr. Chairman. Probably about a year to 18 months in advance was all we received.
Dr. Layton.
Well, first of all, I would say I have been very pleased by the response of Congress to look at these issues. I found it has been bipartisan. I think that there has been a good faith effort on both sides of the aisle to address the issue, and I'm very encouraged by that. What I would just say about our American approach, the merit of it is that we have focused traditionally on sensitive information. We know there are things that are inherently sensitive, health, financial, information about children. So the advantage of that, well, certainly for the taxpayer's perspective, we've focused our resources where we know there was a threat. So under a GDPR world, me as an academic, I have the same liability as a major company. So there are concerns about small entities being unduly burdened. And so I think that there is a real value to the American approach that we've taken.
So Business Roundtable represents some of the largest American companies, not just in the technology sector, but across all sectors of the economy. And I would say that our member companies were definitely engaged in GDPR. They do have a presence on the ground in Europe. However, the European Union is going to take their opinions with a grain of salt, right? Because it's ultimately, these are American companies headquartered in the United States, American jobs. These are, it's about the growth of American companies. They're willing to hear, our concerns, but I don't know how interested they are in addressing them. That said, I think that companies, are very much willing to come to the table now and have an honest discussion about a national standard for data privacy in the United States and how to engage with the European Union and countries in Asia as well to promote an interoperable framework. So we look forward to working with members on that.
Yeah, no, I re-emphasize that word interoperability. We're not going to change the GDPR now that it's in effect, likely. However, I think it's important that we have regimes that are interoperable, and we also put forth our own views on this. I think there was a lot of engagement by U.S. companies and U.S. trade associations, and frankly the government too, with the EU to try to push back or guide this, just like we do in a lot of other areas. I think that can always be stepped up. I'll use the recent example, and it also reflects, I think, a view in Europe that, or for many in Europe, that the U.S. doesn't care about privacy, which is just wrong. I mean, the FTC does probably more actual enforcement of privacy than most of the European entities. However, we need to fill that void. We need to show leadership in this area so there are alternatives, and this doesn't become a global standard. And I'll use the example, the certification regime I talked about a little earlier. I was just in Europe talking to parliamentarians and others about that. A lot of industry is over there talking to them. And there has been changes in that draft law that incorporates a lot of the things that U.S. industry and U.S. stakeholders and global stakeholders wanted, making sure these are industry-driven, making sure they're voluntary, making sure this reflects a risk-based approach. That's important. That level of engagement needs to be continued.
Great. Thank you for all your thoughts. Appreciate it.
Thank you, Senator Peters. Senator Gardner.
Thank you, Mr. Chairman. Thank you to the witnesses for your time and testimony today. Had the opportunity a month ago or so to visit some nations in Southeast Asia. I visited Vietnam about, I think it was the same week that they were considering legislation requiring data localization. And what that would mean for Vietnam, I was trying to understand and explain. Ms. Zheng, when you talk to businesses, when your businesses interact with you, do they talk about the need to share with foreign governments democratic values, ideals, things that we believe in America?
Yes, absolutely. And I would say that there are various forums where we could be pushing that agenda more aggressively. So, for example, in our negotiations on NAFTA, digital trade should be a part of that negotiation. A lot of their, sort of underlying open market, open data flows priorities should be included as part of that. There are also other forums that we should be more actively engaged in, such as the APEC CBPR forum on privacy. OECD is also, I think, taking another look at their privacy principles next year. We need to make sure that not only companies, but also the American government, that we're fully engaged in those forums.
Dr. Layton, what does a country, a government like Vietnam, what do they intend to do with data localization policies?
I'm not sure what Vietnam has in mind. It's certainly of concern to me. I want to punt that question to maybe another person on the panel.
Mr. Painter, Secretary Chertoff, I mean, what does China, Vietnam do with?
So especially with China, but Vietnam has some of these tendencies too. There are various reasons countries have done this. One is to limit market access, which is a concern. One is for a realistic concern, which is very hard to get data for law enforcement purposes. That's addressed by the Cloud Act. I think we need to do more of these bilateral agreements. But the third is to monitor and control their citizens better. And Russia is a good example of this. China is a good example. If you have all the data there, it's much easier to see what your citizens are doing, to monitor them, to have mandatory data turnover legislation to make sure that the intelligence and other services have access to it. That's often what the goal is, and that's harder, and that's why we also have to push back on this human rights agenda along with the economic agenda.
So, Mr. Painter, I think that's exactly right. Secretary Chertoff, what role then should U.S. businesses play? Because a lot of these telecom companies will be involved, technology companies will be involved in the buildup of a localization or data center. So what responsibility does U.S. business have then at that point? How do you balance the need for economic opportunity and growth and market access with the fact that a government that may be using it to target individuals within its own country?
I think that's a challenging ethical problem for companies. It's a little bit like the issue about whether you furnish intrusive surveillance technologies to countries that are going to use it to oppress their own citizens. Now, on the one hand, I think some companies take the view that as long as we're talking about China's desire to have data about Chinese citizens held in China, that's really a matter for the Chinese and they're agnostic. Others view that as enabling something that they see is inconsistent with the culture of openness, and they withdraw. So I do think that we need to think very carefully about the extent to which we enable the kind of behavior on the internet that's really fundamentally inconsistent with our values.
You mentioned in your testimony a cyber NATO. Could you talk a little bit more about that?
Yeah, I think that, we have a regular NATO, which I do think has a cyber dimension, but I think it's Thomas Ilves, the former president of Estonia, who's talked about really having a community of like-minded nations that would defend our cyber assets against attacks, and not necessarily rising to the level of war that would get into Article 5, but even something less than this. I mean, that's attempts to manipulate the political process or engages in systematic espionage or things of that sort.
So, Mr. Painter, when CISA passed Congress, I included legislation that required a U.S. cyber diplomacy strategy. You were there. We had a lot of conversations about it at the time. So given this need for a cyber NATO kind of, or at least this idea of a cyber NATO kind of approach, given the idea of a need to have more agreements with like-minded nations as it relates to cyber behavior, data issues, et cetera, are we on the right strategy? Do we need a path to the right strategy? Do we need a new strategy? Where are we?
So I very much worry that it's not being prioritized, that we're not showing the kind of leadership from the top that we need to do. And there was a lot of work we did, really starting this issue from the ground up, because it wasn't really a diplomatic issue before, and just a number of years ago it was established as one. We're the first office of the State Department that did this. Now 26 other countries, including China and Russia, have those offices. But I think it's important to always look and revise the strategy we have and make it stronger. And that strategy not only helps direct the efforts of the particular agency, but really across the government and other stakeholders so they know where we are in other countries. And so there have been a number of things that were ordered as part of an executive order early in the administration on cybersecurity issues. We still haven't seen a strategy come out of that. We haven't seen a comprehensive strategy of how you pull all these agencies and others together. Obviously, the 2011 international strategy was a good document, but that was 2011. Things, have continued to advance, so we need to make sure we're fine-tuning and prioritizing. I'd say one other thing we did in the State Department is we had every regional bureau did engagement strategies around all these issues, and we'd had 2 versions of them to really fine-tune those efforts. That needs to be done too.
Do we need an ambassador, cyber ambassador at State Department?
I think we do. I mean, I'm very supportive of the Cyber Diplomacy Act. I testified in the House about it. I think it's a really a good approach. I hope it passes this chamber as well. I think that really will help elevate our game, and I think that'll be important. And it's not just the ambassador position. It's really the structure that gives this heft and priority.
Thanks. Thank you, Mr. Chairman.
Are the panelists all in agreement on the concept of a cyber NATO? Does anyone wish to take issue with that? No one steps
I think
forward.
it depends on. I think it depends on how it's formed. I mean, I know Thomas Lewis is a friend of mine as well, and it just depends on the details of how this gets put. But certainly, the idea of having like-minded countries come together in the common defense against shared threats—that's an important concept.
And based on that description, it's something that would be interesting, but we haven't formed any sort of a position on that yet. We're just hearing about it.
Mr. Chairman, if I could just ask, it
Yes.
surprises me that we don't have such a thing. I mean, why don't we have it? What's the closest thing we have to such an agreement?
NATO does actually work together. They have a Center of Excellence, and they do address this issue. Now, the issue becomes, I think, in part at what stage you reach the level of actually invoking Article 5, and whether that needs to be somehow adjusted in the context of cyber activity. I will say that in 2007, when I was secretary, we did work with Estonia when they were attacked by the Russians with a big denial of service attack. So I don't think this is a big stretch. It may just be more a question of kind of formalizing what has been operating for a while.
And it could be also upping NATO's game more on this. I mean, I think NATO has done a lot of things. Cyber is one of the key concepts of NATO, and that was back now about 7 or 8 years ago. And the last few communiques for NATO, cyber has played a key role. There's a lot of focus on both defending NATO countries' assets, but also what they can do in terms of responding to threats. And then part of this is going to be beyond NATO. If we're going to impose costs on adversaries like Russia, that's going to be us working with other allies. It's not necessarily going to be all of NATO, but it's going to be a subset of us, and we need to be able to do that.
Important testimony. Thank you, Senator Gardner. We now have Senator Hassan.
Well, thank you, Mr. Chair, and thank you, Ranking Member, for this hearing, and thank you to all of the panelists for being here today. I wanted to start with a question to you, Secretary Chertoff. On the topic of cybersecurity, I want to address Russia's ongoing attacks on our election system and on our electrical grid. Last week, the Wall Street Journal published a story that stated that Russia's military and intelligence had consistently sought to hack U.S. utilities and critical infrastructure. In a few instances, Russia's state-sponsored hackers even gained access to the utilities' control systems. As one DHS official stated, this is a quote, "The Russian hackers got to the point where they could have thrown switches." The Russians' penetration of one of our nation's most important utilities certainly conjures up fears of a Russia cyber attack that would leave American communities without electricity for days, weeks, or even months. While serving as Secretary, Mr. Chertoff, you helped stand up the National Protection and Preparedness Directorate, NPPD, at the Department of Homeland Security, which is charged with defending against cyber attacks and strengthening the security around our nation's critical infrastructure. Given your history with this mission, could you please discuss how DHS can better defend against these Russian attacks on our utilities and what sort of tools and relationships are needed to stop these attacks? I know there was a discussion about this new hub that they're thinking about, and that sounds to me like a good first step, but what should we be doing?
So I agree. I think this hub is a good first step. You know, when I was in office, we actually talked about co-locating the principal actors in the private sector, critical infrastructure, together with our government officials so we could really work in real time in identifying threats. We're not there yet, but I think this is a good step forward. I would continue to press that, as well as giving clarity to some of the elements of critical infrastructure about exactly what they need to do. One of my recommendations has been to take the Safety Act, which applies in giving liability protection for certain counterterrorism technologies, and extend that to cybersecurity, so you would create an economic incentive for companies to invest in processes and technologies that would lower their risk of cyber. So I think that's one area we ought to be focused on. The second, candidly, is we need to have a clear doctrine about how we respond to various kinds of intrusions by enemy or adversary nations into our critical infrastructure. You know, we know what we did in 1963 during the Cuban Missile Crisis when missiles were positioned in Cuba. What happens when malware is positioned in critical infrastructure? Do we treat that as espionage and reconnaissance? Do we treat it as positioning a potential weapon? I think we need to have clarity and a discussion about what our strategic response is to these varying levels of threat. I know in the NDAA, there's a provision for a Project Solarium in cyber, which would be the equivalent of what we did after the invention of the atomic bomb to develop a doctrine. And I think having a doctrine and having a strategy and a set of rules of engagement would go a long way in creating some element of deterrence to what right now I think is a very ambiguous and challenging environment.
Well,
say one
sure,
thing on
yeah.
that. I think that's the critically important part that's missing. We don't even have a declaratory statement that things like a Russian interference in our election, the big NotPetya worm that caused economic damage, or this prepositioning, is something we're going to take action on and impose costs on. We need to do that. We need to do that now.
Well, that's very helpful. And on the issue of the private-public, not only interaction and partnership being important, it's something that I agree with you on, and that's why today Senator Portman and I are introducing a bill that would establish the DHS Cyber Incident Response Team Act, and it would authorize in law DHS's Cyber Hunt and Incidents Response Team and allow select private sector cyber experts to participate in these teams. So we're trying to move this forward. I appreciate that insight very much. I also take to heart the point about having a doctrine and really treating cyber attacks as the threats that they are and the attack on our country that they are. Mr. Chair, I'm just about out of time, so I will yield it back. Thank you very much, and thank you all to the panelists again.
But we didn't have a doctrine in 1963 until it happened, did we, Secretary Chertoff?
I think in 1963, what we relied upon was a view that essentially positioning missiles very close to the United States was sufficiently a warlike act that we could engage in a blockade. I think we called it a quarantine to kind of fuzz it up a little bit. But I think it relied upon principles in the physical world that were relatively well accepted. It gets much more complicated in cyber because, first of all, people loosely use the word attack. Sometimes it just means espionage, which we've never regarded as an act of war. Sometimes it means literally something that could result in loss of life, which is unquestionably an act of war. And then you have this middle position. So this is, I think, a much more ambiguous set of circumstances than the physical world.
Thank you very much. Senator Udall, you've been very patient. Senators have come and gone, and you've stayed here.
Thank you, Chairman Wicker.
You're recognized for 5.5 minutes.
Thank you. Thank you, Senator Schatz. Appreciate the panel being here today. As a member of the Foreign Relations Committee, I'm particularly concerned about how powerful tech-savvy countries like Russia and China limit access to the Internet in their own nations by banning and controlling any dissent online, while simultaneously using the same banned platforms like Facebook to sponsor and promote disinformation in the West and in the U.S. We are now all too aware of Russia's pervasive misuse of social media in our 2016 election and the Brexit vote in the U.K. The U.S. has a critical role, I think, as all of you have been talking about here, to play, ensuring that we are deterring this kind of state-sponsored disinformation campaign while promoting an open and global Internet. Russia's, and I guess this first question, but others can comment, is Mr. Chertoff and Mr. Painter. The Russian malicious cyber activity remains a national security threat, no doubt about that. They attacked our 2016 election and sponsored the destructive NotPetya malware. What are the most important actions our government should be taking to deter Russia from this type of malicious activity? And just focus on, say, 1 or 2 or 3 like that, I think would be good.
Well, I think when you deal with ransomware, particularly ransomware that can potentially affect industrial control systems and have an impact on human life, I think that deserves the kind of response that we would do with respect to a physical attack that might have a threat to human life, which means we have to have the ability to respond either in kind or in another way to deter that. When it comes to information operations, which to be honest go back 100 years to the Comintern when the Soviet Union existed, I don't regard that as an act of war. I do think it's a matter where there are things we can do in terms of calling out who's really responsible for putting posts up, or things like the Internet Research Agency in St. Petersburg, where they use armies of trolls to drive stories. But I think legally, as well as in terms of our general set of values, we don't want to actually censor content, even if we know it to be untrue and false, because the cure for falsity tends to be truth. And once you go down the road of censorship, it doesn't really stop.
And I would add to that, I think that we've seen a lot of malicious activity from Russia, and the DNI has said that Russia is one of the 4 most damaging cyber actors or capable cyber actors: China, Russia, North Korea, and Iran, but Russia really at the top. And Russia has hit us in a variety of ways, including NotPetya, including the election interference, including this pre-positioning. And yet, we haven't really done anything to affect Russia's calculus in any of that. And so we don't want to be overly escalatory. We're not going to shut off the lights in Moscow, for instance, but we should do something that will actually affect Putin in his decision-making in the future. And there has been this effort now to call out things. There's been in NotPetya, a number of countries got together, and I think that's good to build those alliances and have countries to come together and say that Russia was responsible. Great, but you're not going to name and shame Russia. You actually have to do something that's going to have an effect, and that goes to the doctrine question. And that also, I would think, in the U.S., there's other things we could be doing, like having a task force, a high-level task force to deal with election interference. As a cyber guy, I don't think we really saw this coming. We saw threats to infrastructure, we saw espionage, but this hybrid attack is something that requires a real concerted approach. And the declaratory policy I talked about is important too. And look, we can do sanctions, we can do all the tools we have, diplomatic sanctions, law enforcement, others. But if we don't have high-level messaging and consistent messaging from the top, that undercuts all those efforts. So if you send a message that this is unacceptable, then send a message, well, maybe it's okay, that just undercuts everything we're doing.
Yeah. Mr. Chertoff, or do any of the other panelists want to weigh in on that?
I wanted to say thank you for bringing up this concern, and I certainly agree with the panelists. What I just want to emphasize, I think when that we can think about threats to our security, not just from maybe from military, but they're economic threats. And if I have any bit of advice for Congress, I think we haven't paid attention to the rise of Chinese platforms. 2 years ago, the Chinese app market exceeded the United States in revenue and downloads. And I know a lot of people who already use the Chinese versions of Amazon and Google and so on, and they don't want to open their markets to the United States. They want an indigenous technology strategy, but they want to come and take our market. So I would like to put up that the threat of China from an economic perspective for our digital economy is just as great as a cybersecurity threat from Russia.
Do I still have my 30 seconds? Yeah, okay.
Can I just add one other thing, I think? One other thing I think we need to focus on. The Chinese have indicated that in the next few years they want to become global leaders in artificial intelligence. The way you build artificial intelligence or machine learning is with data. And it's not a surprise that we've seen some incredibly large data thefts in the last few years, like the OPM theft, Yahoo, not Expedia, one of the other credit companies. But I think we need to be mindful that these kinds of data thefts, while they may not seem that critical, actually can be feeding a very significant growth in artificial intelligence capability, which may be what we're talking about in a committee like this in 5 years.
Yeah. You mentioned, Mr. Chertoff, on the misinformation, and the answer is truth. We should be mindful, because the frustrating thing is there's an old saying in the West, a lie gets halfway around the world before the truth puts on its boots. So we need to realize by being open like that, we're also taking a hit at the front end. But we have faith that it will prevail in the end, that the truth will prevail. Thank you very much. Thanks to the panel.
Well, Senator Markey, are you ready
Ready to go?
to jump in front of Senator Cantwell?
It's a privilege to be at such an important hearing today. And Mr. Painter, in your written testimony, you state that the future viability of the Internet as a platform for commerce and social good depends on that platform's security and the long-term stability of cyberspace. I share your belief in the importance of cybersecurity, and I'm particularly concerned about cyber threats of the IoT, the Internet of Things, or the Internet of Threats, which it is simultaneously, where our devices, our appliances, our machines now connect with one another. Mr. Painter, the EU is currently considering a Cybersecurity Act, which would create a single cybersecurity certification standard for information and communication technology devices. I have introduced similar legislation in Congress. The Cyber Shield Act, my bill, would establish an advisory committee of cybersecurity experts from academia, industry, consumer advocacy communities, and the public to create cybersecurity benchmarks for IoT devices, such as baby monitors, cameras, cell phones, laptops, and tablets. IoT manufacturers can then voluntarily certify that their products meet those industry-leading cybersecurity and data security benchmarks and display this certification to the public. Mr. Painter, are you supportive of establishing voluntary standards like this in order to inform consumers and catalyze industry investment in cybersecurity?
So I think the U.S. has a history of advancing these things. NIST, for instance, for the critical infrastructure, the NIST framework. I think in this area, this is a lot like a UL list.
UL?
Well, the Underwriters Laboratory, where you saw on very electric things saying this is something that's safe. And I think it has a lot of merit. I think it makes a lot of sense, particularly if you look at a couple of things. One, voluntariness. Two, built with the industry that it's meant to apply to. So the industry, and it's not a one-size-fits-all, and I don't read your bill to be that. I read your bill to be built with industry, with this advisory committee. I think also it needs to be risk-based, so you're not necessarily prescribing a particular technology, but you're looking at what the risks are involved. I think all those are good things. I think that's a lot of the comments that the U.S. stakeholders have had in the EU Cybersecurity Act that they've taken. The one thing I'd also be cautious of is to make sure that it's not creates a conflicting regime with what's being done in the EU, but at the same time, I think it would show U.S. leadership because a lot of countries are thinking about this. I know Singapore and a number of other countries are creating consortiums and other people to look at IoT regulation and artificial intelligence regulation. I know DHS and Commerce put out some principles on this about a year and a half ago, but I think this kind of voluntary regime built with industry has a lot of merit.
Do any of the rest of you agree that a voluntary regime could work in the United States using that kind of a framework? Yes, Mr. Secretary.
I agree with that, and something I suggested a little bit earlier might also be relevant here, which is to take the Safety Act concept, which we use with respect to counterterrorism technologies, and apply that over here as well, because it creates an economic incentive to get the certification, since the Safety Act caps liability and damages. So I think that kind of approach would be very worthwhile.
Okay, thank you. And Ms. Zheng?
I was just going to add, I think I want to reiterate Chris Painter's point, which is interoperability is a key issue here. One concern is that if there is a voluntary regime here in the United States for IoT that dictates how IoT products are designed or developed or maintained, that other countries would also feel that that gives them license to develop their own national approach. And there again, you have tremendous fragmentation. So, you know, I'm happy to hear that the approach that you're thinking is inclusive of industry and developing it, but I think that fragmentation concern is real.
And Mr. Painter, if I may, Secretary Tillerson chose to downgrade the cyber coordinator position, your former position, last year. Even as we know there's an intensification of cyber attacks on our country, we know that there is malicious cyber activity coming from North Korea, from Russia, from China, from other places. What's your recommendation as to what our government should be doing in order to elevate rather than downgrade this role?
So I think the threats are only increasing. The policy threats are increasing, the technical threats are increasing, the actors that are attacking us, whether it be transnational organized criminal groups or nation states, are increasing. We have to make this a national priority. We can't afford to demote this issue or make it a boutique issue that's only dealt with by the cyber people. This has to be an ingrained national priority from this administration, from every administration. And I think downgrading these roles and downgrading the roles of the White House sends the wrong message to both our friends and our adversaries. We need to lead in this area.
Yeah, I agree with you. I think the Trump administration made a big mistake. We will, in fact, put the laws on the books that we need. I'm afraid it's just going to come after we have a catastrophic event in our country, and then everyone will say, who knew this could happen? We know this can happen. That's what you're testifying today. We should put the preventative laws on the books. Thank you, Mr. Chairman.
Thank you very much, Senator Markey. Senator Cantwell.
Thank you, Mr. Chairman, and thanks for having such an important hearing, and I've really appreciated the testimony of the witnesses. You've all said very illuminating things as it relates to our challenge as a nation, both on the commercial side of working together on tightening up where we are, and certainly, Mr. Chertoff, you talking about the attacks to the grid and the large-scale efforts on things like Ukraine can be very devastating to the United States. And Mr. Painter, thank you for articulating that we needed to be doing much, much more than we're currently doing. That's why last week my colleague and I, Senator Graham, sent a letter to the President saying, please step up both on the assessment side and the resource side, because this is a pretty big issue. But one thing I wanted to ask about writ large, given all of your testimony, because I agree, I don't think provocation comes anymore with a foreign sub sticking its nose in U.S. waters or a plane flying over. I think provocation comes from this kind of hacking of a power plant or pipeline or something of that nature that we are seeing in other parts of the world. So I think this debate has gotten a little off course as it relates to what we do and what other people do. And I just wanted to be clear, since you're all articulating an international focus, should it be clear, and should the United States lead such an effort, that any attack on an election system, that is the actual system itself, to interfere with an election should be something that we should unite the entire world, that is a cyber crime and should be prosecuted?
Yeah, well, very much so. I think we saw two aspects of this. One, the attempted attack on the election infrastructure itself, and also the influence operations. So we meet those in two different ways, but absolutely, if you look at critical infrastructure, yes, we're working about pre-positioning on power grids and other things. But if there's an attack that really undermines the democratic foundation of our system, that's a huge deal, and we need to take that seriously. In this commission that both Secretary Chertoff and I are on, this Commission for the Stability of Cyberspace, we just recently released a proposed norm for governments and others to take up, which is exactly that. You should not attack the systems, the devices, the mechanisms that are used for elections, for democratic and other elections. And I think that's a key thing. So absolutely, and I think that's one of the things we should continue to have discussions with other countries on. We know that the Dutch, we know the Germans, the French, and others have also, and the Estonians, and almost all the Baltic countries have seen this. So it is absolutely a big deal.
Is everybody else in agreement with that?
What I would just like to add, I really welcome that Congress is taking the concern, taking this up. But what I think it's important to say that there has been desire by other countries to influence our election for decades. So, this isn't the first time it's happened. I mean, it's great that Congress responds now, but this has been going on for a long time. And just to pick up the point, I applaud that Congress is going to pick up legislation to look at particular areas we need for cybersecurity.
No, I'm asking you whether you believe in an international, that we should be leading the charge internationally to say that anybody who tries to influence with the election process in a cyber way is a cyber crime, and that we should unite the world against that. That's what I'm asking.
Okay. No, what I would like to express to you is I think that the cyber concern has been maybe for 25 years now, and we have been slow to fully integrate it into the military. So I don't think we need to make the silo. I think it should be fully part of the military from the ground up. We don't need to have to call it that. And so there's been some resistance to because of maybe the way the established defense departments are. They have their turfs that they have been reluctant to bring cyber in integrated as they should.
Trust me, that's why I'm working with Senator Graham, because the two of us are going to keep focusing on this. Mr. Chertoff?
No, I have to say, I completely agree that we ought to work with all of our like-minded colleagues overseas to say that interfering with the actual infrastructure of elections is completely off limits and unacceptable. The information operations gets challenging because while we should resist them, we need to be careful how we articulate it, because if you go to Moscow, they'll say, great, let's get rid of, the National Endowment of Democracies and
I agree. That's why I'm bringing this up, Mr. Chertoff, because I do not want to lose action on the first part.
Correct.
And we should be leading the charge. No government should be involved in interfering with the actual election operations. End of story. We should be leading the charge. But there are some people running around this town basically saying, oh, well, there's this other stuff, and we all do it, and we should let this go.
Yeah,
no,
totally
we
different.
should not let this go. So,
I agree with you. They're totally different. We should not blur the lines in a way that blunts our ability to respond.
thank you, Mr. Chertoff. Thank you.
Thank you, Senator Cantwell. Senator Cruz.
Thank you, Mr. Chairman. Good morning. Welcome to each of the witnesses. Thank you for being here. Dr. Layton, this past January, as you know, a memo leaked from the National Security Council, which called for nationalizing the 5G mobile broadband networks. And since then, the administration has been less than clear in rejecting that idea. I and many members of the Senate consider that to be a profoundly bad idea. That's why Senator Cortez Masto and I together introduced the E-Frontier legislation last week, which would prohibit the federal government from nationalizing our nation's commercial telecommunications network without authorization from Congress. Dr. Layton, in your judgment, what would it mean if the federal government were to nationalize our nation's 5G networks?
That would be a disaster. I saw the press release today, and thank you and Senator Cortez Masto for your leadership. It certainly helps me sleep well at night. But I would say if there's one point that we know in telecommunications policy that we have evidenced over and over again is that governments should not be running the telecommunications network. It has been a colossal waste of money, colossal waste of energy, and it's not where we should put our resources, particularly when we have private companies who are willing to put up $300 billion to have all kinds of competitive 5G networks. So it's not where we should put our money.
So in your judgment, is the E-Frontier Act the right direction for this committee and Congress to go?
Absolutely.
Does anyone on the panel disagree? Does anyone think that the federal government nationalizing 5G is a good idea? Secretary Chertoff, what are your thoughts on the implications if the government were to try to nationalize 5G?
Well, again, I'm not sure exactly what that would look like. I'm not sure exactly what that would look like, but in general, I think...
I think your microphone is off.
In general, I think nationalization of a function like that stifles innovation and puts the government in a position which overreaches in terms of what its proper role is.
Mr. Bladel, there has been considerable attention devoted in Congress and in the national discussion to the role of tech companies and social media companies engaging in political censorship. What do you think the role, and what does GoDaddy think the role should be, of tech companies censoring the speech of others?
So thank you, Senator. I can't speak for the entire industry, but from GoDaddy's perspective, we do not want to be an arbitrator of free speech. We don't believe that's an appropriate role for us as a private sector company. We are supporters of an open and internet that supports free expression and welcomes all views. That said, we do have terms of service for using our platform for communication, and there's some very specific cases that would cause us to suspend or terminate service. Illegal activities, threats of violence, and pharmaceutical sales, and things that are called out in our terms of service. So any content complaints that we receive are subject to a case-by-case review, and then we decide according to our terms of service. But as a private sector company, we do not want that role.
So I think you would not find disagreement when it comes to shutting down criminal enterprises, conduct that clearly violates criminal law. What does obviously raise questions is when it's not criminal conduct, it is simply content that may be offensive, that may be wrong, but that is not illegal. And then the question becomes, who should be the gatekeeper? Who decides what speech is permissible and what speech is not? Have there been instances in your company's history where, because of disagreement with content, you have shut down access to a website?
So typically, that as part of that review, the content would have to contain illegal materials or rise to the level of a direct call for or threats of violence for us to take action.
You obviously operate within the tech space. Should social media companies, in your judgment, be neutral public forums? Should they respect First Amendment principles and allow, as John Stuart Mill put it, the cure for bad speech to be more speech rather than a priori censorship?
So in my view, and I think this is shared by GoDaddy and other companies in our space, is that we want the internet to be as open and welcoming as possible for free expression, and that it's not the role of the platform to judge content on whether it's offensive or whether it's allowable. It should only be on those narrow cases of illegal materials.
Thank you.
Thank you very much, Senator Cruz. Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you to all of you. We have a judiciary hearing going on, so I just snuck down here, and I want to thank you for your work. As many of you know, I've worked, because of my role on judiciary and rules in this committee, I've worked really hard on this issue, and I really see this, what happened to us in the last election, as a cyber attack, and there are plenty of good issues that were raised here by my colleagues about the power grid and other things, but I want to focus on this, and I'll start with you, Mr. Chertoff. I know you mentioned the bill I have with Senator Langford, the Secure Elections Act, which would basically streamline information sharing between federal and state agencies. It was quite an outrage that our 21 states that were hacked into, many of them didn't find out for a year, and that way they can't protect themselves because they don't know what other hack was going on in another state. So my first question is, do you think our states are adequately prepared? You know, we got the $380 million out in the last budget agreement, and what else should we be doing to protect our voting equipment?
Well, I think there's greater understanding now they have to get engaged, and they have to get engaged with DHS. And when I was at Aspen a couple weeks ago, I mean, the word we got from DHS was that all the states to some degree are engaging now. But to be honest, this ship is going to take a while to turn around. You've got aging infrastructure in many places. I think some states are not even fully aware of how much they're connected to the internet.
You also have 14 states that have either no paper ballot or partial paper ballot.
Right, and that's going to require a change in equipment and change in protocol. So the short answer is we're not where we need to be. We're moving in the right direction. We ought to press the accelerator on this. I don't know that we're going to have this problem fixed by 2018. I would be very doubtful. But certainly we're going to have elections in 2020, and by then we should have had the problem fixed. So we've got to step it up.
And what's Microsoft's Defending Democracy initiative doing to help state and local officials?
What they're trying to do is, and I think it's a relatively new initiative, is work with a lot of different groups to both help people understand what the threats are. I mean, I think at a public forum we had in Aspen, they indicated that, in fact, they had identified some candidates whose databases had been hacked. I think raising awareness, sharing information about technical solutions, and working both in terms of raising the game on infrastructure protection and more generally on information operations. They're looking to kind of support all these efforts.
Okay, and then also on the front of the political ads, as you know, it wasn't just about elections and candidates, it was also disrupting democracy with issue ads. That's why I've introduced that Honest Ads Act with Senator McCain and Warner. Do you agree that it's important that we have uniform standards across platforms for these ads?
Yeah, absolutely. It's crazy to say that we can require for television ads or newspaper ads, but not to do it for platforms. And let me just add one other thing. This is not just about elections. I think that we are seeing and we will continue to see Russian efforts to motivate people to have civil disorder, where they get both groups on the right and the left to come to the same place, and they try to gin up violence.
Thank you. And those are the issue ads that are included in our bill, but some of the platforms are saying, well, we should just do candidate ads, which is not the standard for radio or TV or newspaper. And we've seen what they were doing in energy issues and other things where they actually had a financial interest, Russia did.
Yeah.
And I think they've been overlooked because of the obvious focus on the 2016 election.
Yeah, that's exactly right.
Okay, Dr. Layton, my last question here. Over the last few years, we've seen personal information be disclosed. We are proud of our social media and internet companies in the U.S. They're incredibly innovative, and a lot of smart people are working there. But yet, even Mr. Zuckerberg at his hearing has said that we need to put some rules of the road in place. They don't have to be exactly what Europe did. We can do our own. And could you comment on the Social Media Privacy Protection and Consumer Rights Act that Senator Kennedy and I introduced?
Well, you know, I want to applaud you for your leadership, and I think if anybody thinks Congress is not up to task, you've proven them wrong. You know, you guys were very quick to turn something around, and I'm very grateful for that. So I mean, I think in this hearing, this is exactly the steps that we need to take in terms of, and this is the conversation. It would be wrong to say, oh, you know, Europe did this, let's hurry up and get our version. I think that's a mistake. I think that this committee is going through the necessary steps. It's taking in the input from all the stakeholders. And, you know, I think my particular feedback today is the two important components that we haven't included that's very important is the consumer education component, as well as we need incentives for privacy-enhancing technologies. And that's why a safe harbor that would allow a company to innovate a new technology, they wouldn't be punished for it, for example, because we know the first time you make a version of your product, it may not work. And so there's no kind of we need a safe harbor for that permissionless innovation. I think that your bill had a provision for that, and I thank you for that. I think ultimately we'll win this through innovation, science, and technology.
Okay, thank you very much. And the rest of the questions I will do on the record because I'm out of time. But Ms. Zheng, I did have a question about data localization and the problems that creates, and we'll just do that on the record. And then Mr. Painter, I'm sure I'll have some cyber attack question to ask you about. So thank you very much.
Thank you, Senator Klobuchar. I have a letter dated today to Senator Schatz and me from Pat Kane, Senior Vice President of VeriSign Incorporated, and I ask unanimous consent to place it in the record at this point. Without objection, that will be done. We're told that another distinguished member of the committee may be on his way. Senator Schatz, I think this has been a very excellent hearing. Perhaps we can filibuster for another moment or two. Of course, there are dozens of questions we could ask. You know, Dr. Layton, are you speaking for AEI or on your own behalf today?
No, thank you for giving me that opportunity to clarify. As my submitted testimony shows, that I do not represent the positions of AEI or any other entity. I'm speaking purely in my own capacity. I also am a visiting researcher at Aalborg University in Copenhagen, Denmark. We have a center that works on privacy and security research. So my work is, I'm not speaking for that center, but it is informed by the research that we do there.
And Ms. Jung, you are speaking today on behalf of Business Roundtable,
That's
are you
correct,
not?
sir.
Yes. You know, I noticed AEI published an article just a few days ago with regard to the $5 billion EU fine against Google, and it stated the EU's record $5 billion fine for antitrust violations involving its Android operating system is protectionism masquerading as consumerism. It strikes me that AEI has got a point there, Dr. Layton.
Well, AEI doesn't make any official positions. We have over 200 scholars. We all have different views. We have major debates within our organization. Sometimes we have more anger against each other than people outside the AEI. So we actually take very disparate positions because we believe in the competition of ideas.
Very good. Would anyone else like to comment on that? Mr. Bladel.
Senator, thank you. Yes, I think that from our perspective, it just shows what we're up against in terms of the EU's willingness to impose fines on U.S. tech firms, whether that's coming in from this particular instance, which is involving a mobile operating system, or whether that's coming from something like GDPR. It's one of the reasons why we're proceeding very cautiously in our compliance efforts with regard to those European regulations.
Seems that all is not well between our government and the EU. The hearing record will remain open for 2 weeks. During this time, senators will be asked to submit any questions for the record. Upon receipt, the witnesses are requested to submit their written answers to the committee as soon as possible. Thank you all, and this hearing is now adjourned.